ಹಲೋ ಎವ್ರಿವನ್, ವೆಲ್ಕಮ್ ಬ್ಯಾಕ್ ಟು ಮೈ ಯೂಟ್ಯೂಬ್ ಚಾನೆಲ್. ನಾನು ನಿಮ್ಮ ಅಂಜಲಿ ಬಲರಾಮ್. ಇದೇ ಕ್ವಶನ್ ಪೇಪರ್ದು ಪಾರ್ಟ್ 1, ಪಾರ್ಟ್ 2, ಪಾರ್ಟ್ 3 ನೀವೇನಾದ್ರು ನೋಡಿಲ್ಲ ಅಂತಂದರೆ ನನ್ನ ಯೂಟ್ಯೂಬ್ ಚಾನಲ್ ಇದೆ, ಹೋಗಿ ಚೆಕ್ ಮಾಡಿ. ಅದ್ರದ್ದು ಕಂಟಿನ್ಯೂಷನ್ ಇದು. 76 ಕ್ವಶನ್ ಬಂದು, ವಿಚ್ ಆಫ್ ದ ಫಾಲೋಯಿಂಗ್ ಇಸ್ ಜನರಲಿ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ಅ ವ್ಯಾಲಿಡ್ ಕಂಡೀಷನ್ ಫಾರ್ ಅ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಸ್ ಪರ್ ದ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ 1955? Option A, the parties should not have a spouse living at the time of the marriage. Option B, the parties should be with a degree of prohibited relationship. Option C, the parties should not be subpoenas each other. Option D, the parties should not be suffering from epilepsy. ಸೊ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ದ ಪಾರ್ಟಿ ಶುಡ್ ಬಿ ವಿತ್ ಅ ಡಿಗ್ರಿ ಆಫ್ ಪ್ರೊಹಿಬಿಟೆಡ್ ರಿಲೇಶನ್ಶಿಪ್. ಸೊ ಸೆಕ್ಷನ್ 5 ಆಫ್ ದಿ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ 1955 ಏನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ವ್ಯಾಲಿಡ್ ಕಂಡೀಷನ್ಸ್ ಅಂತ, ಅದರಲ್ಲಿ ಇದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ಅಂದರೆ ಅವರು ಮದುವೆ ಆಗೋ ಟೈಮಲ್ಲಿ ಅವ್ರಿಗೆ ಬೇರೆ ಮದುವೆ ಆಗಿರಬಾರ್ದು, ಅವರು ಸಪಿಂಡ ರಿಲೇಶನ್ಶಿಪ್ ಇರಬಾರ್ದು, ಅವ್ರಿಗೆ ಎಪಿಲೆಪ್ಸಿ ಅನ್ನೋ ಕಾಯಿಲೆ ಇರಬಾರ್ದು, ಇದನ್ನೆಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಸೆಕೆಂಡ್ ಆಪ್ಷನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ಆಪ್ಷನ್ ಬಿ ಇಸ್ ದಿ ಆನ್ಸರ್. ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್. Section 13A of Hindu Marriage Act 1955 provides for the following. Option A, grounds for restitution of conjugal rights. Option B, grounds for judicial separation. Option D, grounds for divorce. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಎ 1 ಅಥವಾ 2, ಆಪ್ಷನ್ ಬಿ 2 ಅಥವಾ 3, ಆಪ್ಷನ್ ಸಿ 3 ಅಥವಾ 1, ಆಪ್ಷನ್ ಡಿ ಓನ್ಲಿ 3. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ಸೆಕೆಂಡ್ ಮತ್ತು ಥರ್ಡ್ ಒನ್. Because Section 13 Clause 1 of the Hindu Marriage Act deals with the grounds for divorce and judicial separation, not a restitution of conjugal rights na mention madilla, only judicial separation and divorce. Next question. What is the meaning of the battle marriage in Muslim law? Option A, valid marriage. Option B, void marriage. Option C, voidable marriage. And option D, irregular marriage. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ವೈಡ್ ಮ್ಯಾರೇಜ್. ಬಿಕಾಸ್ ಅಂಡರ್ ಮುಸ್ಲಿಂ ಲಾ battle marriage is considered as void marriage. Next question. What is a contract of marriage which may be dissolved by the wife under a power delegated to her called under the Muslim law? Option A, talaq us sunnat. Option B, talaq ul biddat. Option C, talaq I tafzir. Option D, talaq A asan. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ, talaq I tafwiz. Because it is also known as delegated divorce, and it is one of the most important forms of divorce under Muslim law, as it gives a Muslim woman a right to divorce their husband without going to court of law. Next question. A Hindu boy and a Hindu girl may be married under the following law. Option A, the Hindu Marriage Act 1955. Option B, the Special Marriage Act 1954. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಎ ಓನ್ಲಿ 1 is correct. ಆಪ್ಷನ್ ಬಿ ಓನ್ಲಿ ಸೆಕೆಂಡ್ 1 is correct. ಆಪ್ಷನ್ ಸಿ ಬೋತ್ 1 and 2 are correct. ಆಪ್ಷನ್ ಡಿ ನೈದರ್ 1 or not 2 is correct. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ, ಬೋತ್ 1 and 2 are correct, because Hindu boy and Hindu girl may be married under both Hindu Marriage Act 1955 and also they can marry under Special Marriage Act 1954. So option C is the answer. Next question. Through which of the following Amendment Act the right in the co-personary property is made available to girl child as well? Option A, the Hindu Succession Amendment Act 2002. Option B, the Hindu Succession Amendment Act 2004. Option C, the Hindu Succession Amendment Act 2005. And the option D, the Hindu Succession Amendment Act 2006. We all know option C, the Hindu Succession Amendment Act 2005 is the answer. Because the Hindu Succession Amendment Act 2005 empowered the women to claim co-personary rights over ancestral property and made them legal joint heirs of the family. Next question. What should be the age difference between the adoptive father and his adopted daughter for a valid adoption? Option A, 15 years. Option B, 18 years. Option C, 21 years. Option D, no specific age difference required. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ, 21 years. Under section 11(3) of the Hindu Marriage Act 1955, if the adoption is by a male and the person to be adopted is a female and the father at least 21 years older than the person to be adopted. Next question. Which of the following case may be considered as the first reported case of PAL in India? Option A, SP Gupta versus Union of India. Option B, Husainara Khatun versus State of Bihar. Option C, MC Mehta versus Union of India. Option D, Kalyaneshwari versus Union of India. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ಹುಸೇನರ ಖಾತೂನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರ್. In this landmark judgment, which provided wider interpretation of Article 21 of Indian Constitution, it was held that speedy trials is the fundamental right of even citizen guaranteed under Article 21. It further emphasized upon speedy trial and free legal aid for the effective administration of justice and equality among the citizens. Next question. Who among the following is considered as the father of PAL in India? Option A, Justice S.R. Das. Option B, Justice V.R. Krishna Iyer. Option C, Justice P.N. Bhagavati. Option D, Justice H.R. Khan. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ, ಜಸ್ಟಿಸ್ P.N. Bhagavati. Next question. Against which of the following of PAL cannot be filed? Option A, against a state government. Option B, against central government. Option C, against a private party. Option D, against municipal corporation. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ, against private party. ಬಿಕಾಸ್ PAL ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಹಾಕೋದು ಲಾಸ್ಟ್ ಪೀಪಲ್ ಅಲ್ವಾ, ಲಾಸ್ಟ್ ಪೀಪಲ್ಲು ಎಗನೆಸ್ಟ್ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಅಥವಾ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಅಥವಾ ಎನಿ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಎಗನೆಸ್ಟ್ ಹಾಕ್ಬೋದು. ಎನಿ ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಇದ್ರೆ, ಇಂಡಿವಿಜುವಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರೆ ಅದಕ್ಕೆ PAL ಹಾಕೋಕ್ಕಾಗಲ್ಲ, ಅವ್ರದ್ದು ಓನ್ ಕೇಸ್ನ ಅವರು ಫೈಲ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. Next question. In which of the light of the guidelines issued by the Supreme Court of India on which of the following issues a PAL cannot be entertained by the court? Option A, bonded labor matters. Option B, petition from jail for premature release. Option C, matters pertaining to neglected children. Option D, petitioner cannot police for refusing to register a case. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಬಿ, ಪೆಟಿಷನ್ ಫ್ರಮ್ ಜೈಲ್ ಫಾರ್ ಪ್ರಿಮೆಚೂರ್ ರಿಲೀಸ್ ಇಸ್ ದ ಆನ್ಸರ್. As per the Supreme Court of India guidelines, the petition for premature release are not matters which deserve to be treated petitioner under Article 32, as they can effectively be dealt by the concerned High Court. Next question. In which of the following landmark case it was held that principles of natural justice were applicable not only to judicial and quasi-judicial functions but also to administrative function? Option A, A.K. Kripak versus Union of India. Option B, Ram Javaya Kapoor versus State of Punjab. Option C, Sonika Industries Rajkot versus Municipal Corporation Rajkot. Option D, Maneka Gandhi versus Union of India. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ, A.K. Kripak versus Union of India. In this case, Honorable Supreme Court observed that the principle of natural justice could be applied even to so-called administrative activities, not only judicial ಅಥವಾ quasi-judicial functions. Next question. In which of the following judgment the Supreme Court had comprehensively recognized SP Sampath Kumar versus Union of India case? Option A, J.B. Chopra versus Union of India. Option B, L. Chandra Kumar versus Union of India. Option C, R.K. Jain versus Union of India. Option D, S.K. Sarkar versus Vinay Chandra Mishra. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, L. Chandra Kumar versus Union of India. So this case prospectively overruled the Sampath Kumar case. It was held that the power of judicial review over legislative action vested in High Court and the Supreme Court under Article 226 and 32, and the power of judicial superintendence over decisions of all courts and tribunals within their jurisdictions are basic structure of Constitution. Next question. Who among the following defined administrative law as the law relating to controls of governmental power? Option A, Ever Jennings. Option B, Verde. Option C, Casey Davis. Option D, Garner. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ವೋಡೆ. ಇದು ಫುಲ್ ನೇಮ್ ಬಂದು ಹೆನ್ರಿ ವಿಲಿಯಂ ರಾವ್ಸನ್ ವೋಡೆ. He describes that administrative law is the law relating to the control of governmental powers and largely consisting of general principles of judicial review. Next question. What penalty is prescribed for persons illegally practicing in courts under the Advocates Act 1961? Option A, imprisonment up to 3 months. Option B, imprisonment up to 6 months. Option C, imprisonment up to 9 months. Option D, imprisonment up to 12 months. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, imprisonment up to 6 months. So section 45 of the Advocates Act 1961 prescribed that any person who illegally practicing in any court shall be punishable with imprisonment for a term which may be extended to 6 months. Next question, which provision of the Advocate Act 1961 empowers the Bar Council of India to prescribe the standards of professional conduct and etiquette to be observed by advocates? Option A section 42, option B section 42A, option C section 48A, option D section 49. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ ಸೆಕ್ಷನ್ 49. Section 49 clause C of the Advocates Act 1961 empowers the Bar Council of India to prescribe the standards of professional conduct and etiquette to be observed by the advocates. Next question, which of the following is incorrect according to the Bar Council of India rules? Option A, an advocate can plead in any matters in which he is himself pecuniarily interested. Option B, an advocate shall appear in court at all times only in the prescribed dress. Option C, an advocate shall not stand as a surety for his client. Option D, an advocate shall not influence the decision of a court by any improper means. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ. ಆಸ್ ಪರ್ ರೂಲ್ ನಂಬರ್ 9 ಚಾಪ್ಟರ್ 4th part 2nd of the Bar Council of India rules, an advocate shall not act or plead in any matter in which he is himself pecuniarily interested. Next question, which of the following authority acts as an appellant authority against the order made by the disciplinary committee of the Bar Council of India? Option A, Chairman of the Bar Council of India. Option B, Vice Chairman of the Bar Council of India. Option C, High Courts. Option D, Supreme Court of India. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೆಕ್ಷನ್ 38 ಆಫ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಆ್ಯಕ್ಟ್, ಎನಿ ಪರ್ಸನ್ ಅವ್ರಿಗೇನಾದ್ರು ಡಿಸಿಪ್ಲಿನರಿ ಕಮಿಟಿ ಕೊಟ್ಟಿರೋ ಅಂಥ ಡಿಸಿಷನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್ ಆಗಿಲ್ಲ ಅಂತಂದರೆ ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾಗೆ ಅಪೀಲ್ ಹೋಗ್ಬೋದು. ಸೊ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ. Next question, in which of the following situation a one-person company OPC will mandatorily get converted into either private or public company? Option A, in case the paid up share capital of an OPC exceeds 25 lakh rupees. Option B, in case the paid up share capital of an OPC exceeds 50 lakh rupees. Option C, in case the paid up share capital of an OPC exceeds 25 lakh rupees. Option D, in case the paid up share capital of an OPC exceeds 1 crore rupees. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ಇನ್ ಕೇಸ್ ದ ಪೇಡ್ ಅಪ್ ಶೇರ್ ಕ್ಯಾಪಿಟಲ್ of an OPC exceeds 50 lakh rupees, because in case of paid up share capital is one person company exceeds 50 lakh rupees, then it has mandatorily convert itself into private or public company. Next question, what is the minimum number of directors required for a public company as per the Companies Act 2013? Option A 2, option B 3, option C 5 and option D 7. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ 3. So according to section 149 clause 1 of Companies Act 2013, there must be minimum number of 3 directors ಇರಬೇಕು and maximum number 15 directors ಇರಬೇಕು ಒಂದು ಕಂಪನಿ ಫಾರ್ಮ್ ಆಗಬೇಕು ಅಂದರೆ. Next question, which of the following is a landmark case on the public trust doctrine in the environmental law? Option A, Value Citizen Welfare Forum versus Union of India. Option B, Olga Tellis versus Bombay Municipal Corporation. Option C, Indian Council for Enviro Legal Action versus Union of India. Option D, MC Mehta versus Kamalnath. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು MC Mehta versus Kamalnath. ಈ case is a landmark case on the public trust doctrine in the environmental law. Next question, in which of the following case section 66A of the Information Technology Act 2000 was struck down by the Supreme Court? Option A, Shreya Singhal versus Union of India. Option B, Kartar Singh versus State of Punjab. Option C, K.A. Abbas versus Union of India. Option D, Menaka Gandhi versus Union of India. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ, ಶ್ರೇಯಾ ಸಿಂಗಲ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ. On 24th March 2015, the Supreme Court of India in this case struck down section 66A of the Information Technology Act 2000 as unconstitutional on the grounds of violating the freedom of speech guaranteed under Article 19 clause 1 clause A of the Constitution of India. Next question, in which of the following case an electronic record shall not be attributed to the originator as per the Information Technology Act 2000? Option A, electronic record signed by the originator himself. Option B, electronic record signed by an authorized person. Option C, electronic record signed by an automated system programmed by him. Option D, electronic record signed by an unauthorized person. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಡಿ, electronic record signed by an unauthorized person is the answer. Next question, what is the maximum period for which any woman shall be entitled to maternity benefit under the Maternity Benefit Act 1961? Option A 6 weeks, option B 8 weeks, option C 12 weeks and option D 26 weeks. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ 26 ವೀಕ್ಸ್. ಬಿಕಾಸ್ ಅವ್ರಿಗೆ ಮ್ಯಾಕ್ಸಿಮಮ್ 26 ವೀಕ್ಸ್ ಇರುತ್ತೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೆಕ್ಷನ್ 5 ಕ್ಲಾಸ್ 3 ಆಫ್ ಮೆಟರ್ನಿಟಿ ಬೆನಿಫಿಟ್ ಆ್ಯಕ್ಟ್ ಅವ್ರಿಗೆ 26 ವೀಕ್ಸು ಮ್ಯಾಕ್ಸಿಮಮ್ ಪೀರಿಯಡ್ಡು ಮೆಟರ್ನಿಟಿ ಬೆನಿಫಿಟ್ ಲೀವ್ನ ಕೊಡ್ತಾರೆ. ಹೋಪ್ ಈ ವಿಡಿಯೋ ಇನ್ಫಾರ್ಮೇಟಿವ್ ಆಗಿತ್ತು ಅಂತ. ನೀವೇನಾದರೂ ಪಾರ್ಟ್ 1, ಪಾರ್ಟ್ 2, ಪಾರ್ಟ್ 3 ನೋಡಿಲ್ಲ ಇದೇ ಕ್ವಶನ್ ಪೇಪರ್ ಸಾಲ್ವ್ ಮಾಡಿರೋದು ಅಂತ ಅಂದರೆ ನಂದು ಯೂಟ್ಯೂಬ್ ಚಾನಲಲ್ಲಿದೆ, ಚೆಕ್ ಮಾಡೋದು ಮರಿಬೇಡಿ. ಹಂಗೆ ವಿಡಿಯೋ ಇಷ್ಟ ಆದರೆ ಲೈಕ್ ಮಾಡಿ, ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಯಾರು ಎಕ್ಸಾಮ್ ಬರೀತಿದ್ದಾರೆ ಅವ್ರಿಗೂ ಶೇರ್ ಮಾಡಿ. ಅದೇ ರೀತಿ ಜಾಸ್ತಿ ವೀಡಿಯೋಸ್ಗೋಸ್ಕರ ನನ್ನ ಚಾನಲ್ನ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡೋದು ಮರಿಬೇಡಿ. ಆ್ಯಂಡ್ ನಿಮ್ಗೆ ಏನಾದರೂ ಡೌಟ್ ಇದ್ದರೆ ಅಥವಾ ಏನಾದರೂ ಸಜೆಷನ್ಸ್ ಇದ್ದರೆ ಕಮೆಂಟ್ ಸೆಕ್ಷನಲ್ಲಿ ಕಮೆಂಟ್ ಮಾಡಿ. ಥ್ಯಾಂಕ್ ಯು.